This video will cover Chapter 8 from our Labor Relations textbook. The topics are impasses, strikes, and resolutions. We're going to talk about different types of strikes and lockouts, their role in labor relations, and their legal restrictions in the private and public sectors. We'll also discuss the controversies surrounding the use of strike replacements. We'll identify other types of pressure tactics beyond strikes and lockouts and why they are being used more frequently than in the past. We will also compare the major third-party dispute resolution mechanisms and their strengths and weaknesses. There are really two broad categories of disputes. Interest disputes. These pertain to conflicts of interest, typically cover things like higher wages versus lower labor costs, things of that nature, my interests compared to your interests. And then there are rights disputes. Rights disputes are disagreements over whether someone's rights have been violated. For our particular case, those are going to be rights laid out in a union contract. So when we have a rights dispute, we typically go through the grievance process. That will be covered in Chapter 9. We've talked about strikes before. Remember, a strike occurs when employees refuse to work until an employer changes positions on one or more issues. A lockout is similar to that. It's where an employer tells the workers not to return until they agree to particular terms of the employer. By withholding labor or withholding work, each party is attempting to inflict cost on the other. When workers are out on a strike, these strikers seek to increase the cost to the employer of disagreeing by depriving them of their profit. And similarly, when workers are locked out, the employer is withholding wages. So on the next two slides, we'll cover many types of strikes. There are economic strikes. These strikes are over wages, benefits, and work rules. These typically happen during contract negotiations. This is the typical kind of strike many of you think about. This is protected by the National Labor Relations Act. Workers cannot be disciplined or discharged when they're engaging in this kind of strike. However, workers can be replaced with both permanent and temporary strike replacements. A strike for unfair labor practices occurs when workers are protesting against an employer's unfair labor practices. Again, this is legal. Workers cannot be disciplined, discharged, or permanently replaced, so that makes it different than an economic strike. But the National Labor Relations Board must find that an unfair labor practice was committed to be able to protect the workers' jobs. A recognition strike we talked about already. This is a strike to attempt to force an employer to recognize and bargain with a union on behalf of the employees. These occurred frequently in our labor history, but with the National Labor Relations Act, we now have an easier path to using representation elections instead of recognition strikes. These strikes, however, are legal, but there are limitations. Workers can only picket for 30 days. Workers are protected, but can be permanently replaced. Picketing for recognition is essentially limited to 30 days, and after 30 days, the workers can still be on strike, but they're not allowed to picket. Sympathy strikes. These are strikes in support of other workers who are on strike. So if one branch of the company goes out on strike, other workers at other branches may go out on strike in support of them. Or workers from one industry may go out on strike in support of workers in another industry. These may or may not be protected by the National Labor Relations Act. If there is a no strike clause in a contract, that might be a waiver of the protection. In this case, workers would not be protected and can be discharged or disciplined. Otherwise, sympathy strikes are protected, but strikers can be replaced. Wildcat strikes. These are not typically protected. These are strikes over grievances while the contract is still in force. These are not while we're negotiating a new contract. Sometimes these are protected, but typically they aren't. A no-strike clause in a contract usually waives protection for this. This is typically what we find since we have built-in grievance procedures in the contract. If there is a no-strike clause, workers can be disciplined or discharged. If there is not a clause in the contract, grievance strikes are protected. However, strikers can be replaced. Jurisdictional strikes are really strikes over the assignment of work to bargaining unit employees. These are not protected by the National Labor Relations Act. These are strikes where workers believe that work that a unit member should be doing, that a union member should be doing, is being assigned to somebody other than the appropriate party. Workers may go out on strike to protect the rights of the union. Non-economic strikes are strikes over things that you're allowed to bargain on, not required items, but allowed to bargain on, permissive items, during contract negotiations. So the workers go out on strike, but it's not about those things like wages and benefits. These things are not protected by the National Labor Relations Act. The National Labor Relations Act protects the right to improve wages, hours, and other terms and conditions of employment, but does not protect striking for permissive bargaining items. And then you can have broader, more general or political strikes. These are mass protests against government policy. These are actually fairly rare in the United States, but they are much more common in Europe. These kinds of strikes are not protected by the National Labor Relations Act. The National Labor Relations Act protects a worker and their efforts in their particular place of employment, but not at the broader policy level. It should be clear that in the case of a natural emergency, the National Labor Relations Board can try to mediate a contract, and in severe cases, the president can issue an injunction or seize the operation of the company to maintain production. This is highly unlikely to happen, but we can imagine in a time like this with the pandemic, something like that being possible. A key aspect of a strike is a picket line. So you see children here on strike attempting to reduce their work week from 60 to 55 hours. This was in Philadelphia in about 1900. These children worked in the textile mills. After 2.5 months on strike, the strikers ran out of money and returned to work without the reduced work week. Now, a picket line is really important. From this picture, you can read the signs and you can see what the cause is that these children are striking for. The idea of a picket line is to convince the public not to patronize the business and workers not to cross the picket line. It's also to create solidarity among the strikers and to build support for their cause. We can see a significant decline in major strikes in the United States from 1950 to 2016 here. U.S. strike activity is really at an all-time low right now. As you notice here, striking faced a very steep decline in the 1980s. This is because at this point, labor's bargaining power was reduced immensely by policies that were put into place and the economic circumstances at the time. Remember, bargaining power and the threat of a strike affect the extent to which bargaining outcomes favor labor or management. So if workers are less likely to strike, that may mean that management has more power. It's also important to know the use of strike replacements is a very contentious issue. There are permanent strike replacements. Those are people who take the job of the strikers permanently, and temporary strike replacements. Those are people that come in and do the job in the short run, and eventually, once the strikers come back, those workers no longer have a job. Because of a court case of the National Labor Relations Board versus McKay Radio and Telegraph Company that went to the Supreme Court in 1938, we now have the right to go out on strike for unfair labor practices, and these workers are entitled to immediate reinstatement. A key thing to note also is in the case of a lockout, firms are not allowed to hire permanent replacements because then they could always just get rid of the union by locking out all of the workers and replacing them. There are a good number of other pressure tactics that workers have taken part in to attempt to exert pressure on the companies. Workers have done things like boycotts, trying to get people to not consume the good that company produces. They do things like work slowdowns. If we work slower and the bosses aren't able to produce the quantity that they need to produce, maybe they will finally hear us. They also do things like work to rule campaigns. In other words, the employers do just exactly what their job description says they have to do, or that the contract says they have to do. Nothing more and nothing less. Often workers go beyond the requirements of the job, but in a work to rule campaign, this could actually limit the capacity of the firm. We also saw an example of a corporate campaign. Now, it wasn't a successful corporate campaign, but in American Dream, we saw Ray Rogers hold a corporate campaign against the Hormel company. This is really a public relations campaign to attempt to increase labor's bargaining power. Each one of these things, the boycotts, work slowdowns, work to rule campaigns, and a corporate campaign, are all designed to attempt to level the playing field. There are other options to resolve disputes between the company and the workers. Often these involve a neutral third party. The neutral third party is brought in to settle bargaining impasses with the goal of avoiding these costly strikes. In the private sector, having a neutral third party come in is typically voluntary. Sometimes it's written into the contracts. In the public sector, engaging in third party dispute resolution is required. Now you see a matrix here where we have the degree of third-party control over the process and the degree of third-party control over the outcome. So we're looking at what the third party can do to affect the process. I'll start by talking about mediation. This is a case where the third party has a high level of control over the process, but very little say over the outcome. The mediator is brought in to resolve or avoid an impasse, and really what they do is assist in negotiations. The process follows a fairly simple format. The mediator collects information from both parties and establishes the rules of the meetings. The problem solving that occurs here is where the mediator attempts to clarify disputes between the two parties and attempts to help them develop alternative solutions. The focus here is finding a workable agreement that falls between the two parties' desires. A second form of third-party resolution is arbitration. Arbitration is a case where the third party has little control over the process, but a high level of power over the outcome. This involves issuing a settlement that is binding on the employer, the union, and the employees. When I think of arbitration, I often think of a court setting because a hearing is held, evidence is presented by each side, and the arbitrator makes the decision. In conventional arbitration, the arbitrator is not constrained in deciding the settlement terms. That means the arbitrator can decide whatever terms of the contract he or she thinks is appropriate. There's another kind of arbitration called final offer arbitration. This is created such that the arbitrator must choose between the union's final offer to the employer and the employer's final offer to the union for what the contract terms will be. Another form of third-party resolution is called fact-finding. In a fact-finding scenario, that person has little power over the process and little power over the outcome. The fact-finder investigates the bargaining impasse and issues non-binding recommendations for the settlement. The fact-finder develops a set of unbiased settlement terms that can help the negotiators reevaluate their positions and attempt to find an acceptable compromise. This lets the union or management negotiators save face by making concessions under the guise of the report from that fact finder instead of appearing to be weak and giving in to the other side. Making the fact finder report public can use the glare of publicity to push the parties into a settlement. So a fact finder is a little weaker than a mediator, but it does allow both parties to hear what the other side is thinking and where we might come to a resolution. There's also a case where we might have mediation and then arbitration. So some contracts require mediation first, and if mediation cannot come to a settlement, then that mediator may become an arbitrator. The mediator then, after a certain period of time or a certain number of rounds of attempting to negotiate, may just lay out the terms of the contract for both parties. That's all for now. I'll see you again soon.